Thank you, sir. So today I am going to talk about and copyrights, a new strategy for strengthening profiles of faculty and students. I taken this topic because as I am also working with the IIC, so I felt that till now all faculties and students are only concentrating on publication. They are not considering the importance of the patents. So that is why I chosen this topic, so that you will understand what is the importance of patents these days. Okay. So it will add the value or weight in your profile. So, let me start. Content I am going to discuss is I will discuss the basics of the IP rights. I am not going into detail, just for the what are the things that you have to take care and how to proceed if you wish to convert your idea into the patent. Okay. So I will tell only basics, and then I will tell why we are discussing this all these things. So what is the scenario at the institution, university and institution perspective, and what are the importance of patent and copyright faculty or as a student? So general terms, I will like to define property. Intellectual property right has property, and it refers to what we understand as a layman. Like if someone will say to me property, so I will understand, okay, someone is talking about land, or someone is talking about some assets like vehicle or any jewelry. Like this I consider. So if you will see what is property, it is refers to the tangible or intangible assets that are widely acknowledged as being in the legitimate possession of a person or group. So here I am saying two terms, tangible and intangible. So intangible, today we are talking about intangible property. So general terms property, what we understand is it is land or the vehicle, it is tangible because these are physical property. You can see, or you can see the boundaries and you can touch it. But in the intangible property, it is a property that does not derive its value from physical attributes. So we are not talking about tangible property, we are talking about the intangible property. So now I am expanding the word, adding some more word with the property, intellectual property rights. So now I added the word intellectual. So property term in intellectual and the real property, obviously it has different meaning, as I said to you as an example. And this intellectual property now, once I added the intellectual word with the property, has a different meaning. It refers to the inventor or the applicant by the government for his invention, which is a new product or process or mechanism or existing product in a more efficient way than existing art. So, talking about some invention, and this invention should be result as a product, or it can be process, or it can be a mechanism, and it can be invention of the existing art. So intellectual property rights include novel idea. It can be results of research, or it can be a critical business information. So I will elaborate more in further slides. So this intellectual property will be granted by the patent office of a particular country. And the thing that we should remember, that this IP is only for the limited years. Like if suppose it is mentioned that patent is only valid for 20 years, so we have to take care. Once 20 years will complete, then we have to start the process for the renewal. So this is very important point. And next is the IP protection is territorial. So likewise, I said the patent right is territorial in nature, meaning that a particular patent is only enforced in a particular country. Like if suppose I am filing a patent in our country India, that means it will be only enforced in India. And if I wish to file the patent in another country, then we have to file as a separate patent application. So what are the types of the intellectual property? So I am showing you one diagram. And you see here, I divided this IP into some types, industrial property, and this industrial property is further defining as patent, trademark, geographical indication of the goods, design, semiconductor IC layout design, and then trade secret, plant varieties, and copyright. So who is going to take care of all these things? Who is the administration? I am sure that these industrial property, patent, trademark, geographical indications of goods design, all these are taken care by the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry. So this is the department that is taking care. Semiconductor IC layout design, it was introduced in 2000, and it is taken care by the Ministry of Telecommunication and Information Technology. Plant varieties is taken care by the Ministry of Agriculture and Administrators, the Act of Plant Variety, and copyright is taken care by the Ministry of Human Resource Development. So what are these things? I will explain further. So what is patent? So if I am saying patent, that means it is an exclusive or ownership right granted by a country to the owner of invention by the invention satisfies certain conditions. So what type of certain condition it should satisfy? It should satisfy that it should be a new product, or it should be a process involving an inventive steps and capable of industrial application. So I'm saying capable of industrial application. What does this mean? It means that invention is capable of being made or used in an industry. So if suppose someone is getting the patent, that means a letter or a certificate will be issued by the patent office. Next is gives exclusivity of right to the owner. So this patent will implies that no one else can make, use, manufacture or market the invention without the consent of the patent holder. So this will be the power of the inventor or owner, that he can, as per his wish, he can give the consent to use that product by another person. So it is up to the owner only. So next is the available to the owner of the invention only for a limited period of time. So this ownership will be only for a limited period of the time. If suppose I am saying patent, it is only valid up to 20 years. Come to the trademarks. Trademarks refers to the word mark, any picture or any symbol. These things come into the category of trademarks. What is the use of trademark? Whatever be the terms I am talking, patent, trademarks, copyright, all terms are actually talking about the ownership as well as the business. So once we are talking about the business, so we have to consider the competition between the two brands. If suppose, for example, if I say that one company, because of the that their quality of the product, they got the good, they achieve the good will in the market. So, and their product price is high, but an other company, that product quality is low, but it is looking similar. So, so someone how it will identify that this company is offering the good quality, or something that is customer wants. So like Coca-Cola, it is a word mark. So this word mark, if I want to use, I cannot use, because it is now registered with the patent office as a trademark. So the how it is written, it cannot be copied. So you can also use the pictograph. Like here I am showing one animal. So this and this type of figure, or if you will register the color of the figure, that is also valid. Design patent. So in the market, we see many varieties and brands of the same products. For example, if I say there are in the market car, television, a piece of furniture, any mineral water bottle, etc. in the market, which look quite different from each other. But if the products have similar functional features or have comparable price tags, then customer will see the design, it will see the color, or how it looks. So based on that, based on the appearance, customer likes to choose. So like I'm showing one example here. This is the key I'm showing here. So in this this key appearance, you see here, it has two. This is the head of the key, and this is the body of the key. So if I'm trying to file, that means this part I cannot file, because this is the function part. But this head, we can, the head design or head portion, we can register, so that no other person can copy it. So because of this design or product appearance, it will help in brand building in the market. Sometimes people file the design. There is another option. They can file a single design patent with multiple embodiments. So, but in both cases, there is a risk versus cost. Like if suppose each design patent in the design patent suite is independent and stand on its own, if one design patent is invalidated, the other are still valid because they are independent of each other. So all embodiment in a single design patent stand or fall together. If one embodiment is invalidated, then the entire design patent is invalidated. So like this, there is a risk factor as well as there is a cost factor. So you have to compromise by choosing any one, like file a single design patent or file a design patent suite. Come to the geographical indication. Geographical indication is refers to the product that is from a particular specific region, or it has some characteristics, it has some quality, or it has some reputation. So that can be registered as a geographical indication. So for example, Darjeeling tea. So it is a special type of tea from Darjeeling. But the only thing is this geographical indication cannot be filed by a single person. A group of the person can file this geographical indication registry, and it is only valid for 10 years. Conductor IC layout. In this, you can patent transistor associated with the circuitry element, and this circuitry is embedded in the semiconductor material or an insulator material or inside the semiconductor material, and it is designed to perform an electronic circuit function. So if we have any layout that is also that can also be registered in this semiconductor IC layout design along with the interconnection. Protection of plant and it deals with the plant breeding. Generally, plant breeding is a long and expensive biological science, and but the plant varieties can easily be produced. So therefore, plant breeder need protection to recover investment. So protecting this for protecting this plant breeding, this act is helpful. Also, it is taking care of the farmers' right, as farmers are using traditional farming, and farmers are the working as a cultivators and they are conservers. So to reward them, this act is helpful. So it is facilitating the farmers also. Copyright. Copyright, it takes care of the literary, dramatic, and musical work, computer programs, software are covered. This also includes the artistic works and the cinematographic films, which includes the soundtracks or video films. And it also includes record any disc tape. So the thing that is important is whatever be the sound or anything that we are talking, it should be in a physical device. Then it can be copyright. So in this category, as a faculty, we are doing research work. So publications, research paper, and the books are in this category. Trade secret. So this is the another way to stop the use of the particular method or formula or device or process. So if suppose anyone don't want to disclose the ingredient, for example, if I will say that KFC is a very famous brand, and they have the very good number of food chain. So they are providing the food items that have unique taste. So they don't want to disclose that ingredient combination, so they can file the trade secret. So here, no need to disclose the ingredients, but that particular part will be registered. But what are the other things that we can register? If suppose any information that is confidential, it can be registered here. Designs, formulas, ingredients, device, methods. If I don't want to disclose it, that can be registered here as a trade secret. So why we are talking about the patent rights? So all the things that I said to you, it is just to stop the third party to use the product or making a similar product or manufacturing a similar product, the use of the product or sale of the product or importing, distributing or licensing. So all these things can be prevented if you have patent right. particular product. What exactly may be patented? This is important, that patent can be given for the process or method. It can be machinery, it can be apparatus, or it can be art of manufacturing other than the biological process, and it can be composition of matter or pharmaceutical products, or it can be improvement of the existing art. But all things should be noble. So what are the criteria? So in my view, I'm thinking that it is a process or method, it is a machinery. But once we are going to file the patent, we have to meet some criteria. So these are the 4 criteria, like non-obviousness, nobility, understanding, and it should not fall under section 3 and 4. So what are these non-obviousness or nobility? What is section 3, which is which should not our patent should not fall under this section. So these are the some points that we have to see before filing the patents, so that our money or our time will not be wasted. So what is section 3 and listed here? It is also available on the website of ipindia.com. So what is non-obviousness and what is nobility? So for example, if I say toothbrush, I will say as an inventor that I invented the toothbrush. So by saying toothbrush, it doesn't mean that it's editable. You see here, if I am, you see the example here, I'm showing some drawings, I'm showing, all are related to the toothbrush, but in each drawing you see some unique feature is added. So this shows the nobility of this product. So because of this special design, it has nobility. So it is patentable. Non-obviousness. So product should be non-obviousness. It should follow the non-obviousness, means that whatever be the product, it should not be obvious. Like any ordinary skill in the area of technology related to the invention would not find it obvious to the change. Like suppose I will say that I designed one portable computer. It consists of display, keyboard, mouse, battery, CPU, and the SD RAM. And another inventor, that person also produce a portable computer. It also includes the display, keyboard, mouse, battery, CPU, and it is using DRAM. So in this case, you see, it is not obvious. It is a different type of circuitry that is used to store the BIOS information. So these two things are different here. So and it is not obvious. So these two circuitry are specially designed, and their working and their methodology is totally different. So because of this, it is non-obvious. So it can be patentable. So we are patenting a product. So before patenting a product, we have to find out that my product is not meeting any infringement. Like we are not copying other product. So this is very important, because if I am filing patent and it found that it is already there. So in that case, if suppose that party is filing a case, then we have to if suppose it found it is true, then the infringer has to pay amount for damages and profits, and they has to face the punishment. So so this is important thing. While patenting, we have to see whatever be the product or process we want to patent, infringement should not be there. So infringement is common for copyright as well as patent also. So if suppose I have idea and I want to do the patent, so directly I cannot jump to the patent and directly I cannot land to the patent office. So some homework we have to do. So as everyone knows that there is another way, that if suppose I have idea, now these days institutions are establishing the innovation IP cell. So in the IP cell, they have the autonomy, they have the full facility. So if any faculty or student have any idea, they can directly approach there and they can ask to file the patent. But if suppose I am general person and I want to file the patent, then I have to do some homework. So this step is also applicable whenever I am going through the IP cell or I am going directly. So because of this homework, we can save our time and we can save our money. So what is this patent search? It is a prior art search. So it will help us that whatever the product I have, it is patentable or not. It will help us to estimate the scope of the patent protection. And it will also help us to find whether any existing product is there, at any similar product is there, or similar inventions are there. And it will help us, suppose if suppose I want to add some more things in my idea, so it will help me to find out the missing solutions. So whatever missing solution, based on that we can adjust our design or adjust our product method. So if suppose we did this homework, it will help us to prevent us from infringing. So if suppose I want to find out that what your art is available, so we can go to website and we can find out that this. I'm showing the one screenshot of the website I taken from the patents.google.com. In that you see this find prior art option is there. Once you will click here, so whatever be the keyword you search in the prior art search, it will automatically show you the find prior art. Or it will also show the similar things. So these two options you can choose here to find the prior art. So if suppose you want to search for the products that are available in the market, so you can go to the website. I will tell the website addresses where you can write the keyword. So the only thing is you have to find out the exact keyword. So you have to identify the keyword, and you can search with the synonym of the keywords, and you can search with the composition of the structure, or if it is if you know the classification, like if it is in the electrical category. So these are the ways through which you can search the existing prior art. So patent can be done before filing the patent, and it can also be done after the filing patent. Like I'm showing, before filing patent, you can do search for existing state of art. So if suppose I want to see what other patents in the same field are available, so this option will help you to search the existing state of art. So once you will conduct this search, so you will expose to the all relevant and prior art that relates to your invention. And this search will help you to understand recent research, to help you adjust accordingly. So this is very helpful step. So by your own, you can go to the website and you can see the existing state of art. Next is the nobility search. This nobility search also you can do prior to filing a patent application, and this search is actually verify if the invention is new and if you qualify for a patent. So this will help you to see whether your product is novel or not. And this patentability search is most of the means most common search. So generally directly people used to find out the nobility search, and then once I completed the patent process and I have the I filed the patent, then I can do the searches. One is called invalidated search. What is this invalidated search? It search happens after a patent has been issued, and this search aims to locate documents that challenge the validity of a patent because of search research using the original patentability search. So it is done by the another party trying to invalidate the patent. Freedom to operate means it is similar to the clearance search. Once you will get this clearance, that will confirm that you will get the patent. So a patent clearance search can determine if an invention infringes on another patent or not. So once you will get this clearance, you will grant the patent. So what are the website available? So this is the first website that is that will show the patents that are filed in India. Google, it will cover the all over world patents, and this is eSpaceNet, USPTO, and Lens. And last is the WIPO database. So these are the search engine that is available. So USPTO is United States Patent and Trademark Office. So it is offering public patent search. It is a patent search application created by the USPTO, as the public can access the search tool that the examiner use with a single online platform. eSpaceNet, it has a good language translation because patents can be in an English language or in the different language. So if you want to translate, so that the search engine allows you to translate the language. Out of these, this Google is easily help you to search for patent documents, and it is easy. It is very easy accessible. But most of the inventors, they use patent scope. It is a very highly recommended engine, and it has good language translation. So as I said, whenever we are going to search about the patent, not only we have to search in these websites, also we have to search in the database. So some databases are there, like patent, we should cover the products that are existing, as well as we should cover the patent application that are filed and they don't have, means the patent is not granted, and some documents that are published in the journals or conferences, that information also we have to search. So these databases will help us to find the published work in the journals. There are also paid patent searches also there. So free database will help us to search in a first instance, but finally once we decide that now I'm sure that my product is patentable and it is novel, then I have to go to the paid database. Means we have to approach to the professional search, so that it will make sure 100% that my patent application will not be rejected. So to reduce the probability of the rejection, this paid database will help the inventor. So if suppose I have idea, so I will go for the patent search. and then I will build the prototype. So as I said, the idea is not idea is not patentable. It should have some inventive steps, and it should have the industrial application. So this, if suppose I completed the build prototype, then I will go for the non-provisional patent filing steps, and then we will approach to the office, and once the process will complete, then patent will be granted. But suppose my prototype is not ready, and I'm not sure what will be uh, the the feedback of my product. So that to confirm the feedback of my product, that uh, it will meet the customer requirement or not. So we can file, for the timing we can file the provisional patent. So this provisional patent will allow us to complete all these steps in 12 months. So once I will file, that person will file the patent, the provisional patent, then they can float their product for testing in the market and approach to the investor. And once it is confirmed, then they can sell or sell product. If suppose they have capacity to manufacture the product, I suppose they don't have capacity, so they can give the license to another person. So license facility is also there. So this is the optional step. If you are very much sure that your product will be working and it will be unique and it will meet all the requirements, then you can directly go to the non-provisional patent filing. What type of applications are available? So as I said, there are two type of applications, mainly ordinary application. If suppose I want to file the patent, I will file to the ordinary. So there are two options. Either you file provisional application to file using provisional application, or you can use non-provisional application. Patent of addition. So fresh patent, you use ordinary application. But if suppose you file the patent, and after filing the patent you found that some part is may not work, or it may infringe the other product, so you can modify the main application. So if you want to modify the application, rather than filing a separate application, you can use patent of addition. So patent of addition will help to file a separate application. Divisional patent application. A divisional patent application is a application which, like, again, it is a revised version, similar to the revised version. For example, I filed the patent application, but later I found that I should add some more inventive steps, or I should add some more additional claims. So I can file divisional patent application, in which all the claims or all the things that I wrote in the my main application, it will be there. Patent application. If suppose I wish to file patent outside the country, so international application we can file, and there are two ways. One is the PCT route, another is the conventional route. So I'm not going to this international application, but I will show you what means, how, if suppose you are searching for the patent means at worldwide, so what are the information you should see. If I am filing the patent, so we have to follow the 6 step. So I will start from filing the provision application, and once complete application should be complete within a year, and then it will publish. Once it will be published, then you request for the examination. Once examination report will come, that first exam report that if suppose it is, then you will will be patent will be granted. But there are some intermediate steps that we have to meet. Like in this duration from this your 12 months to this patent granted this duration, in this duration, anyone can oppose. Anyone can oppose. Means they can oppose your patent. So for that case, you have to face the hearing. You have to face the hearing, and if it successfully completed, then you will grant the patent. If suppose it is not successfully completed, then refusal. So that if suppose you will have refusal, then also there is a possibility to appeal to the appellate court. So who will deal? All the patent application filing process will be done in the patent office. But if any this type of case is there, any opposition case is there, that will be here in the appellate court. So how many what type of application we have to file? So there are total in our Indian patent side, there are total 33 forms, but all forms are not. First instance, like I'm showing the total forms, what are the forms available, and their form numbers are also listed here. But what exact form we need to file the fresh application, I am listing here. So two type of form we have to fill: legal information and the technical information. So for legal information, we have to fill the form number 1, form number 3, 5, 9, 18, and 26. So what are these form 1, 3, 5, 9, 18, 26? It is written here. So it will contain the legal information, and this form number 2, it will contain the technical information. So for example, you see here I am showing one example of the smart pen and pencil with foldable scale attached. In this, you see here that it contains the field of invention. It contains field of invention, computer science, background of invention, summary of the invention. I will show in the next page, and brief description of drawing, claims, abstract. So these are the things that will be available in the application. So if you wish to see the particular product details, you can go here and you can view the documents. So you see that up to what stage it reached, it is also visible here. So it is started by filed, published, and then argue that examination request is filed and it is under examination. Application status will also be visible for a particular page. So you see here in this, I'm showing, and any drawing you see here, it is showing some numbers. So each and every part of this drawing should be described in the patent, the technical specification form. So this you see, so field of the invention. So this is the example I am showing you here. Background of the invention, summary of the invention, and claims. So this is very important that whatever the claim you are writing here, it should be unique. So it contains, this claim contains 2 parts, main independent part, or another is the claim body part. So this is your preamble. This air replaceable brush head for an electric toothbrush. It is a preamble, and comprising is a transition. This is transition, and then you are going to the, sorry, this is the main independent body from this point to this line to this line, and then it is transiting from 1 to 2. You are transiting, then you are transiting to 3. So these are the transition. Key information. So if you will see the I'm showing one example. So So what information you will find once you will search the existing patent? It will show the title, it will show the assignee or company, and it will show the technology, IPC technology area code. It will show the drawing, and it will show the previous existing patent also. Similar patent, it will list it. It is not complete. It will also show the that patent that it is referenced. So that list also will be here. To come to the, if suppose I want to file the patent, so how much fees I have to pay? So there are two categories. One category is for individual natural person or startup or small entity in educational institution. Another is for others, or natural person or startup or small. So there are two categories. In this, if suppose you are filing the form number 1, you have to pay 1600 rupees. And if you are filing the form number 8, so 800. So there are some fees that you have to pay while filing. Like if suppose you want to request for examination, then you have to give 4000 rupees. So different charges are there that you have to give at the time of filing. So at the first instance, you see that the total fees, if suppose I am filing through this fees for individual category, so I feel that okay, total 5600 I have to pay. But if you go in deep, then you will find that before grant you have to pay 1600 for the filing the application, and you have to pay 4000 just for examination. So 5600 is visible before grant, but once the patent is granted, then you have to pay some maintenance fee. So that how much maintenance fee you have to pay, that is listed here. 3 to 6 years you have to pay 800. So some amount is there. So if you are filing one product, so in a 20 years, how much you have to invest. And some medical filing fees is also there. So the normal application restrict you to file the application within 30 pages, and you can include only 10 claims. If suppose you wish to include more claims, then you have to pay some additional fee. And if you want to add some more pages, then you have to pay additional fee per page or per claim. So 800 for normal applicant, and for special applicant it is 160. So you see that the table in which I showed the additional filing fee. So how much amount you have to invest for your patent, you can understand. There are some offices. If suppose it depends upon where you are staying, based on that you can choose the patent office. So this is the chart I am showing where you can visit physically, but there is another option, like you can file online. E-filing option is also there. E-filing also there. Like if you know that you are going to file the trademarks, then you can approach these offices. Or if you are going for the design patent, you have to approach to the Kolkata office. So different category you have to choose the office. So copyright office you have to approach to New Delhi. Semiconductor IC you have to approach to the New Delhi office. But for the app that hearing aids, you have to approach to the Chennai office. So two options are there. Either you can file online or you can file offline also. You can file directly. If suppose you know how to write the forms, how to fill the forms, you can directly apply, or you can apply through the attorney. So what is today's scenario? So everyone is witnessing the transformation towards Bharat, and thereby accelerating the vision of Atmanirbhar Bharat. So everyone saw how the country come out from the pandemic and how people of the country makes the same to Aapda Mein Aksar, and how we refuse to go down in front of the other countries because of our self-reliant attitude. So in this line, how academia plays critical role in bridging the gap between the India and Bharat. So the institution in the country have long been major agents of change in large economy and society, brought about through knowledge generation and transfer. So Atmanirbhar Bharat has brought the country's focus on MSME. And MSME is one of the key driving force toward the self-sufficiency, because it is providing almost 80% of the workforce. So as MSME are engaging with the academia by investing in the research and innovation, a relationship that can benefit both the institution and industry. In this line, with the vision for the future of work, the demand is for academic institution to create learning experience that uses integrative discipline approach. Integrative discipline approach means students will be trained for the job that are not existing today, but will be in demand in future. Also, institution has to adopt the partnership model, where businesses and other employers such as government, research and institution, and the think tanks help the institution in preparing talents for knowledge economy. So far, institutions were only focusing on the training the students in the skills that are required in MNCs. But now scenarios is changing. Now these agencies, UGC, AICT, NAC, IAC, these agencies are asking to generate some intellectual property. So like UGC is asking to offer IPR subject as an elective in the curriculum. NAC is assessing the institution and accredits the high on the basis of quality indicator framework. So it is asking how many patents you generated, and AICT is also asking to establish the IPR cell. So in the these IC also working to convert the idea of the students and faculty into the startups, and then they should become the entrepreneurship. So these agencies are the universities and institutions have to coordinate with these agencies, as well as now there is a competition. So now there are two things that we are concentrating. One is called ARIA and another is NIRF. So these two schemes are actually deciding the rank of the institution or university or college. So if suppose you see the NIRF rank across the country, it is considering some parameter, like 5 parameters are there. So you see here in this parameter, research and professional practices is there. So if you see the points, so it is very important. If you are applying now, government is making the registration is mandatory for NIRF. So it is mandatory to register for NIRF for each institution, university, and colleges. So each this in NIRF they assign some weight ranking, like here 0.3 is assigned for the research and professional practice and total 100 marks, and graduation outcome ranking weights it is 100 marks. So here only I am concentrating that if suppose I want to gain some marks, so how much marks assigned in the ranking, it is around 15 marks. So for IPR it is 15 marks. So how this helps in the ranking? In this, you see that this is the 2021 NIF ranking chart. In this, IIT Madras got the maximum score. In that, you see 86.76, and it ranks 1. So like this, any institution will get the score and the rank. So each institute, so you see here this RP parameter will show the count. So you see here that total is 15. So each institution they will assign the score for a particular parameters. Ranking also assessing the institution based on their patents, how many patents they filed, how many copyrights they have, and how many design patents they have. So all these parameters, like I'm showing number 2 and number 3. It is showing the particular institution, how many patents they filed, how many patents they published, how many patents granted. So 3-year data they are asking. So that is why the how many patents a particular is filing is important. And also, as you know, that once a patent is filed, it is granted, then that patent should be commercialized. So how many patents that institution commercialized and how much revenue they gain. So that also it is asking. These are the important points. Like we have to take the number of patents, copyrights, as well as we have to see how much revenue is generated by commercializing a particular product, patent, or by assessing a particular patent. So while I'm talking all these things, as we are only concentrating, like in the, once we are doing PhD, we are only concentrating on the research publication, and research publication is automatically directed us to get the copyright. If suppose I am going for analysis, then we have our own copyright. But if suppose I am something like that, publication, so that particular journal will have the copyright. So if suppose I want my want to republish my say book, I have to take permission from the publisher. So if suppose if I want to see how this patent is playing role in the profile, so there are some factors I am showing you here. If suppose you are going for recruitment, they are counting the patent. If you are going for promotion, you are going to from institution, and if you want the funding from the agency, sponsoring agency, and if you want to be the entrepreneurship, and if you want to invest, like I said, that any patent, suppose you are unable to manufacture in a mass scale, then you give the license to another person. So that will give you the value. So if suppose I will talk about the recruitment, so you know there is a credit point policy. So for patent, you see some points are assigned per post. So the number of patent, based on that you will get the points. Similarly, if you have research publication, points assigned. So, journal or UGC, so there are points. So that is why this patent or publication are very much important. Suppose I'm applying for the other institute, based on that they are selecting. In self-appraisal also, it is asking how many patents a particular published points are there. So these points will actually give a weightage as there is a competition. So if you want to get success, then you have to see these points. That this is the way we can get success and we can get the good score. For students also, suppose a student is thinking that only academic profile is sufficient for me for higher education or job, it is now not sufficient. If you are going for higher studies abroad, if you have any patent uh, pocket, then easily you can get the admission in the good institution. Also, if you have a patent, you can also show the recruiter that you have caliber to do the innovative things. So these are these you can add, patents and copyrights you can add in your profile, so that you will get a good chance if you wish to for higher studies or if you wish to get a good job. Also, if you want to be entrepreneurship, also this will help you to start a startup, and it can help you also to use it as an investment. So sometimes people are that publication is and means they are comparing the publication and the. So, but if suppose I am going to publication and then I am thinking now I want to do the patent, it is not possible, because once we publish our research work or the any our work, it will kill your novelty, and it will not, it will prevent the commercialization. So it already, if it is published, that means it is already in the public domain. So you cannot claim as a will work. So while you are doing work and you are thinking whether you have to publish or patent, so you have to do some comparison. So based on the future, like if suppose you have an idea that can be converted into the product, definitely you see what is the market value. Based on that you can decide, because there are some pros and cons. You see, in the publication, nominal fees we need, but for the patent we need to invest some legal fees, as I said to you, filing fees and the maintenance fees. And this publication, it is easy, already you know the procedure. Patent you don't know, so you need help. So but now the thing that government made it easy by establishing the IPR cell, so you can directly go there. But as I said, it includes the some legal issues, so you have to be very much conscious that you cannot, you should not totally dependent on the IPR cell team, or you should not totally dependent on the attorney. You should also know the things what you are writing in the patent, and it should not cover the other person, means it should not infringe, that you should know. So in the publication, no need of professional help. For the patent, you need a professional help. And in the publication, once you publish, uh, you will get the one-time incentive. It is the case of the publication research paper. If suppose you are doing book, then you will get royalty of this. And if you are doing patent, you can also get the royalty. But it depends upon the market. In the research, you have to show the theoretical concept, but in the patent, you have to show the nobility, that is steps and the utility. So all these things show that where, if suppose you have idea or you have any research work, so if suppose it can be converted into the product, so it will help you or not, you can judge. So if suppose you are planning that you want to file the patent or you want to publish it, so it is also possible. So before publication, if you think that this is the idea that will uh, come that will result in a good product, so it is better to file the patent, that provisional patent, and then you do the good publication, that publication. So that is possible. but the constraint is the filing procedure you have to complete within a year. So what government policies, some government policies change. So government recently reduced the filing fees, as well as it allows to expedite the examination. So these are the two changes in the policy. So before going to this side, like patenting or publication, you have to think about some points that I am showing you here. That how much cost you have to invest. So you have to see the your capacity, that how much you can invest. Or if suppose you file the patent, then you have to remember to pay the annual fees or any renewal fees. So this you have to remember. If suppose any infringement case arises, that also you have to handle. So these things we have to take care, whether this patent filing is time consuming or lengthy process. But if you see the positive side, once it will get success in the market, then obviously it will help you to get the gain. But if suppose if you go for negative side, that, this negative side will come once you will not complete the the homework. So the homework is very much important. Patent search is very much important, that you can do at your end by using the free database or free patent search engine. So the possibility of this negative side will go low. So this is all about this patent general information, as well as the how it will help you as a faculty or students. So if you have any query, you can ask.